Smart startups are doing whatever they can to keep their costs low, especially in the very beginning. That's why I'm surprised that more startups don't take advantage of some of the free or really inexpensive patent and intellectual property strategies that really create a lot of value but are super cheap. That's why this video is going to be the top 5 cheap or free IP or patent strategies. So if you're new to the channel, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions, which is used worldwide, including top universities like Harvard, Stanford, and MIT. You might also recognize me from being featured on CNBC's hit show, The Profit, with Marcus Lemonis. In my practice as a patent attorney, I work with clients of all sizes, including Fortune 100 companies, startups, and Shark Tank companies. And this channel has a lot of the secrets and information as, how I help these clients be successful. So be sure to subscribe, click that little bell icon so you get notifications of when new content comes out. We've got a lot of great stuff on this channel about startups and patents. So let's go ahead and get right into that list. And number 5 is the Circle C, or the copyright protection notice. So you can put a Circle C on pretty much anything that you want to assert as having copyright protection over. You don't have to file a federal copyright registration to use the Circle C mark, and it's a great way to show things that you see to be important as far as copyrightable material. Again, totally free, and you can put it on anything. And that's why I'm surprised that more startups don't do this. It's a way of, showing that certain things are proprietary to you, showing that you have intellectual property and you take it seriously. And at the same time, you don't want to put it on everything. Make sure it's used appropriately. For instance, don't put it on your business name. That's going to be better things for you're going to want to have a trademark symbol on that. We'll talk about that in another entry. But yeah, you can use the Circle C on anything. And one thing to keep in mind about copyright is that by actually putting something into tangible form, by putting it out there, you actually get protection on it. You get some basic common law copyright protection just by putting the thing out there. And putting the Circle C on there helps to reinforce that protection. It's not absolutely required, but it helps show other people, hey, this is something that I consider to be important. Copyrights are not like things like patents. With patents, you start automatically losing patent rights upon a first public disclosure, public use, or offer for sale. But with copyrights, you actually get protection once you actually put things out there. So use that Circle C on anything that you see as being important for copyrights. Again, it's free. More people should be taking advantage of it. And number 4 is the TM symbol. And so you may see by catchphrases or slogans or logos, a little TM symbol. You can actually put that on anything you want, and you can do that right now today for free. You don't have to file a federal trademark registration to put the little TM symbol on something. And by doing that, the little TM symbol shows that, again, you consider this to be important intellectual property. This is a part of your brand, and it shows that you're asserting trademark protection. What you don't want to use is the Circle R. That is only allowed to be used once you've filed for a federal trademark registration, you've gone through the process and actually been issued a federal trademark registration. That's the only thing you don't want to use, but most people don't know the difference. They don't know the difference between the TM and the Circle R as far as being federally registered and not being federally registered. Trademarks, kind of like copyright, you actually get protection by using those things. So when you start using your business name in commerce, you start using a logo in commerce, you start using a product name or a slogan in commerce, you actually get protection for that. And it's reinforced and it shows people that you're serious about this thing by putting the little TM symbol on that. Again, totally free and something that you can do right now, and it's something that more startups should be doing. And number 3 is patent pending marking. So this is one, it does require a little bit of cost because it does cost something to file a provisional patent application. But at the same time, I'm always surprised by people who take the time and effort to file a provisional patent application or even the non-provisional patent application, and don't mark their products, or in marketing materials, don't describe their products as patent pending. It is one of the easiest and, at that point, free ways to get some good marketing for your product and for your company. And it's surprising how few companies actually promote that. For instance, like on the product itself, like, you should say patent pending. On the tags, it should say patent pending. In marketing materials, in pitch materials to investors, to people who want to license the idea, you should say that the product is patent pending. You've spent the money on patent application, and you should market that. It's always surprising how startups, they want to spend the money on patent protection, but then don't actually market that. There is so much value in marketing the fact that you have pending patent applications, or then even issued patents, and that should be marketed. The best way to do that is to mark those things as patent pending. But again, you have to have filed a patent application. This is not something where it's like you do the mail it to yourself patent, as some people call it. That's not a patent. You have to file a patent application with the United States Patent and Trademark Office, and then you can call yourself patent pending. And that can last for a long time, and the marketing benefit of that can be huge. One, I kind of mentioned, it's beneficial. Like, investors love to see that. People may want to license the idea, but it's also really good for potential employees, potential partners. They say, hey, you're patent pending. You have a patent portfolio. This is a company, or this is a product that is new and is innovative. This is something I want to be a part of. Similarly, with customers, people say, "Hey, this is a patent pending product. There must be something special about it. It must be innovative. It's differentiated over the other things out there. They're not patent pending. They're not patented, so they must not be as special. This is something that has special technology in it, right?" So this marketing is really important for all the people you're going to be engaging with. And aside from those positive things, for, say, business partners and potential clients, things like that, there's also the deterrent effect. People see patent pending on something, and it doesn't make it clear what is patent pending and what's not. Is it the method of making it? Is it the product itself? How broad of protection is that? And with provisional patent applications, those are held in secret. So it's not like they can look it up and try to figure out what the patent protection is on, right? What is actually patent pending. People can't look that up. And so it kind of creates uncertainty in the marketplace, and people out there, and I see this a lot with people who come to me and they say, well, there's this competitor, they have this product, they say it's patent pending, and I actually tell people the truth of that, but most people, that scares people off, and you're never going to get a sense of that value. No one's going to come to you and say, oh, I didn't come into the market, I didn't try to compete with you because I saw your patent pending marking. But there's a lot of value in that. There's a lot of deterrent value in even just being patent pending. So that's why I'm surprised that more folks don't mark their products or their materials as patent pending when they can. Number 2 is marketing with published patent applications. So let me kind of step back as far as where patent publications are going to occur and what I'm talking about as far as marketing with published patent applications. So in the patent examination process, when you file a non-provisional patent application, 18 months after your priority date, so it would be, if you file the provisional, it would be 8 months after you file the non-provisional, or if you start with the non-provisional, it'll be 18 months after that. By default, that patent application is actually going to publish. It'll be publicly available at the USPTO. And this publication is really important for marketing and something that I see people not taking advantage of. The reason is because the way this publication looks, it looks really official. It's got USPTO on it, it's got a number, it's formatted, and it looks almost identical to an issued patent. There are a few things that, if you know what you're looking for, you can tell right off, hey, this is a publication number, not a patent number, but most people do not know the difference. You can have the one cover sheet of your published patent application, and people look and be like, oh my gosh, you have an issued patent. This is awesome. This is really cool and looks official, right? I'm always surprised why people don't market that more. Like in their marketing materials, have the front page of the publication that looks really awesome and official. Have that as part of your pitch. It can be a page of an appendix, and it's something that makes a huge difference when it comes to marketing. You can also link to those things at the USPTO, or link to them, say, on like Google Patents, so that people can look it up and see how official it looks. Or have a PDF on your website that people can then go to, or have an image of what that publication looks like. You've paid all this money for a non-provisional patent application. Use the benefits of it for the publication. And it kind of goes into another thing. There are a lot of people who say, well, I don't want my patent application to publish because then people will know what's going on. And sure, there's potentially some downside to that, but the publication is really important for marketing reasons. And if you don't allow it to publish, you don't get that benefit. There's also the benefit, which is of stopping other people from patenting similar things. So if somebody else tries to patent something similar, that publication is used against them as prior art. That's another benefit. That's another free benefit from the publication. That one's going to happen regardless. But using the published patent application in marketing, really, really important. And again, I don't know why more folks aren't doing this. And number one is splitting patent applications. Okay, and this is the thing that I am always amazed why more folks don't use this amazing strategy that can, with a little tiny extra cost, can effectively double, triple, or more, triple the perceived value of your patent portfolio. And it just is crazy to me. So let me explain what I mean by this. So when you file a patent application, a lot of times people, they want to be cost effective and throw everything into one single patent application. And that makes a lot of sense. But when it comes to the perception of, say, investors or the public, they're going to be looking at the number of patents or patent applications in terms of value of a company's patent portfolio. So a patent portfolio that has one patent application versus one that has 10, the one with 10 is perceived as having 10 times as much value as the patent portfolio that just has one patent asset to it. Just as much as, if you have 5, it's 5 times as more valuable than just having one. But the reality is that when you file a patent application, you can choose to file multiple patent applications instead of just one. And you can do so selectively. So for instance, let's say, in one single patent application, you can talk about, here's a method of manufacturing the product. Here's the method of using it. Here is a description of the actual product itself, right? You could easily split that up into 3 separate patent applications with a ton of overlap on stuff that's in there. You can split it up into 3 applications instead of doing it as one, and then you have a patent portfolio that is perceived as being 3 times as valuable. Yes, there's going to be a little extra cost in terms of filing fees, there's going to be some there, and there's going to be a bit of extra cost because it's, if you work with an attorney, it's going to take them a bit more time to file 3 applications. But let's just say it costs, 1.5 times, the cost of just doing one application, which I think is a bit high, to be honest. It probably is going to be a lot less. But let's just say it costs 1.5 times to do 3 versus just doing 1 patent application. Okay, so for 1.5 times the cost, you get a perception of 3 times the value instead of just filing 1 patent application. So that's something to keep in mind. It's not appropriate for all companies. So for instance, if you're not out there and you're not pounding the pavement looking for investors, it doesn't make a lot of sense. You might as well just throw everything into one single patent application because, who cares about the number of patent assets? Unless there's going to be somebody on their side who's going to be looking at that in terms of numbers. So it doesn't always make sense. But for folks who are raising capital, it's a cheap way of getting a lot of extra perceived value and getting investors excited. At the very least, having more than 1 patent application makes a huge difference instead of just having one. People don't know the difference between one big omnibus patent application that covers 100 different inventions and all these different things. They see that as being equivalent to having 3 short patent applications, and it's really easy to split these things. So again, another one of those strategies that I'm surprised why more startups are not taking advantage of because of the relatively small cost and the huge benefit that you get out of it. All right, so that's my list. I'd be curious to hear what your thoughts are. Are there any other strategies that you've heard of that you think I missed? Would you prioritize things differently? And have you done any of these things? Are you doing any of these things? Or do you disagree? Do you think it's like totally a waste to do some of this stuff? Would you never do it? Is it not applicable to your business? Let me know down in the comments below. I'd love to hear your thoughts on this stuff. And be sure to subscribe to the channel. We've got a lot more great content on patents and startups. Hit the subscribe button, hit that little bell icon so you get notifications when our new videos come out. And give this video a like if you enjoyed it. The YouTube algorithm loves it. We'd love your support for this channel so we can put out more great patent and startup content. Thanks for watching, really appreciate it, and we'll see you again in the next video.